Thank you very much. I'm Emily Saunderson. I'm a barrister at Quadrant Chambers. I specialise in banking and financial law and also in commercial fraud. And in this QBiT talk, I'm going to explain how to get a freezing injunction. Now, a freezing injunction is one of the nuclear weapons in the court's arsenal. What it does is it freezes a defendant's money and other property to stop the defendant from dissipating their assets or moving the assets outside the jurisdiction of the court to frustrate any judgment that you're going to get against that defendant, usually at some point in the future. It's always urgent, and you usually go before you've told the defendant that you're even going to start proceedings against them. It's a very serious order because you're interfering with somebody's rights over their own property. And also a breach of the order can result in the defendant going to prison. And as I've said, you usually go without telling them that you're about to go for an order, which gives rise to all sorts of duties to the court on you as lawyers and on your clients. So it's very important that before you go for the order, you're thoroughly prepared and that you know that you're going to tell the court anything that might count against you in terms of getting the order. Now, I think there are 4 basic steps to getting a freezing injunction. The first one is that you have to check that you've met the test. Now, there are 4 elements to the test. The first is that you need to show you have a good arguable case. Now, a good arguable case is a case that's more than barely capable of serious argument, but not necessarily one where the judge believes you've got more than a 50% chance of success. And it's not a particularly high hurdle, so it's rarely a problem for you to actually persuade the court that you've got a good arguable case. Secondly, you need to show that there is evidence of the defendant's assets. The court will need to know that this order isn't going to be in vain. There will be assets to freeze. So assets within the jurisdiction for a domestic order or assets outside the jurisdiction for a worldwide order. Thirdly, and this is incredibly important, you need to persuade the court that there is a real risk that if the court doesn't make this order, the defendant is going to dissipate their assets. Now, if you've got a cause of action against the defendant which involves allegations of dishonesty, you're probably going to be able to get past this hurdle fairly easily. But the court is going to be quite wary about just assuming that because there's dishonesty involved, the defendant will dissipate their assets. So you need to be quite careful to make clear that the specific dishonesty you're alleging gives rise to an inference that there is this real risk of dissipation. If the defendant has got their assets in a complex offshore structure, or if they've got a history of dissipating assets, obviously that will help. Finally, you need to persuade the court that it's just and convenient to make the order, and to be honest, if you've already got through the other 3 hurdles, you're probably there. The court will grant the order or find that the test is met. So the second of the 4 steps in terms of getting an order, assemble a team and come up with a plan of action. Getting a freezing order is a real team effort, so work out who's going to be involved and get them together. I think the minimum number of people you need is 3. You're going to need somebody to do the advocacy, somebody to sort out the evidence and deal with the client, and another person who's very good at document management to get the exhibits sorted out and get the court documents, the bundle for the hearing together. You're going to need more people in a more complicated matter usually. You need people who are going to be willing to work unsociable hours, work through the night, because as I said, it's usually very urgent. And very importantly, you're going to need a reliable point of contact with the client. So somebody who will pick up the telephone when you call with questions and will know the answers to the questions or know how to get the answers to the questions. Work out when you're going to go to court. Give yourself a deadline. That will focus everybody's minds. And work out which court you're going to go in. If it's very urgent, my advice would be to go in Court 37 in the Royal Courts of Justice, straightforward Queen's Bench division. You can usually get on pretty quickly there. If you've got an underlying Chancery claim, obviously you can go in the Chancery interim applications list, and other divisions of the court will allow you to set up ad hoc hearings in front of a judge. But you need to get in touch with the court early, make sure that they know that you're coming with an urgent hearing, and they can try and help you to get a judge lined up. So the third thing you need to do is get the documents sorted. Now, there are 3 key documents you're going to need for this application. The first is the evidence, which is going to be an affidavit with an exhibit. Secondly, you're going to need the draft order, and thirdly, you're going to need the skeleton argument. You're also going to need an application notice for the without notice hearing, an application notice for the return date, which is when you come back having told the defendant that you've got the order, and a claim form. And the claim form is pretty straightforward. You certainly don't need to have particulars of claim ready to go at this stage. The affidavit is probably the most important document. You obviously need to set out the facts that give rise to the cause of action against the defendant, and you need to show the court that the test for a freezing order is met. As I've said, you're going to be without notice, so you've got a duty of full and frank disclosure to the court. You as lawyers and your client has got a duty as well. If there are any points against you, any reason that you shouldn't get the order, you need to make sure that those are set out clearly in the affidavit. If they're legal matters, you need to make sure they're set out in the skeleton. My tip for dealing with the full and frank disclosure issue is to keep a running list while you're preparing for the application of points that occur to you, reasons why you might not get the order. If you've got substantial history with the defendant, if your client has got a long-term relationship with the defendant, the advice to the client is probably going to have to be, we won't pick up every point because there's just so much they might raise on the return date. If it's an invoice fraud, a straightforward invoice fraud, you probably won't have so much of a problem. You're going to need to highlight any evidence that you're relying on where there's a potential issue, for example, if it's been illegally obtained, or if it's going to be open to attack because there are holes in it, gaps in the narrative. You need to highlight that, make sure you've dealt with it in the affidavit. Explain any delay. And don't feel that you've got to leave these points unanswered. You're making points against yourself. You can say, yes, but the answer to that point is whatever. Give the judge reasons to make the order rather than reasons not to make the order. You need to say in the affidavit why you're going without notice. It may sound blindingly obvious, but it's a requirement for the affidavit. You need to include evidence of the sum that you're seeking to freeze, which will include interest and legal expenses. Make sure that's covered in the affidavit. You need to give evidence as to your client's ability to meet the cross-undertaking in damages. Now, if you're working with a corporate client, the gold standard would be their latest management accounts. Now, often those aren't available, and what you'll actually get is the latest statutory accounts. Now, these are usually very out of date, so you're going to need to take instructions about material changes that might affect the client's ability to meet the cross-undertaking in damages. Leave the swearing of the affidavit until after the hearing. This means that you have got as much time as you possibly can to include any new developments that arise before the hearing. Now, the exhibit is a crucial document, and my absolute top tip for getting a freezing order is to make sure you get the exhibit compiled early. Get somebody working on it, somebody who's good at document management, who will know that you put all the similar types of documents together, all the correspondence should be together in chronological order. Paginate the exhibit, make sure everybody has a copy. It's just a lot easier if everybody's working from the same set of documents. Then you've got the order. Now, there are two standard forms of order. You're going to need to choose which one is the most appropriate for your case. My suggestion would be to work from the standard form and put any changes in track changes and show the judge the track changes version so that they know where you're departing from the standard order. There are a number of things that you're going to have to think about. The return date, keep it as soon as possible. You can always vary that later. Name any assets that you know about, so properties, bank accounts, that sort of thing. Think about the disclosure provisions, what you're going to be asking the defendant to tell you about their assets. Always allow a reasonable sum for living expenses, and think about whether you need to ask the court to give you notification provisions if they undertake a transaction in the usual course of business, which is over a particular level. Finally, don't relax when you get back from court. Don't put your feet up and think, thank goodness that's all over. You need to go through the order and make sure that you are fulfilling any undertakings that you've given to the court. Get the affidavit sworn, get the note of the hearing written up, get everything out to the defendant and the third parties who need to see the order. And that's it. Thank you very much for watching.